Every day in the USA, people find themselves in court.
We will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Mr. Sonnenberg, who is appearing in person in custody without counsel. We're set here today on two matters. Well, actually, three matters, Mr. Sonnenberg. One is a return on warrant. An arrest warrant was issued, a warrant for your arrest for a body only. You were arrested, you are here, your body is present. And so the court is going to quash that warrant. And the second thing is now for the court to set bail and get bond conditions. And the third thing is an initial appearance. I have to do two of those three things, but the initial appearance I can either continue today, or I can adjourn it to a different day and allow you to apply for a public defender or retain your own private attorney so that you can have an attorney with you at that initial appearance date. Because you have 5 charges against you. One is first-degree recklessly endangering safety and F felony, use of a dangerous weapon. The second is resisting or obstructing an officer, an A misdemeanor as a repeater. The third is violating an harassment restraining order, a U misdemeanor. The fourth is criminal trespass to dwelling, an A misdemeanor. Oh, the violating restraining order, U misdemeanor is a repeater and has a domestic abuse enhancer. The fourth criminal charge is criminal trespass to a dwelling, an A misdemeanor, as a repeater and with a domestic abuse enhancer. Count 5 is disorderly conduct, a B misdemeanor, as a repeater and with the domestic abuse enhancer. So there are 5 serious charges against you. So either we can go through and have the initial appearance here today by yourself with you representing yourself, or you have the option to say, you know what, Judge, I want to and I need to apply for a public defender, and I'd like to have an attorney with me. So please set that for another day so I can have an attorney with me. So you can either do it yourself or I can move it to another day. Okay? All right. So do you know what you wish to do? Would you like to move forward with your initial appearance here today, or would you like me to move it to another date and time?
I'd like to move forward.
You would like to move forward and set it for a preliminary hearing, because that's what I'm going to need to do because it has a felony, and with a preliminary hearing, I'm going to need to set it, and it's going to need to be within like 10 days. Your next hearing.
I'll just go forward with me represent myself as today so I can get bond.
Oh, I'm going to set bond anyway.
Oh, okay.
Bond will be set.
Okay.
So I'll set, why don't we do that first? We'll set bail first, then I'll ask you that question. All right, Mr. Schmidt, argument and bail recommendation, please.
I would ask for a bond of $50,000 cash. In terms of failed appearances, he doesn't have that many. The last one I can find is from 2023 in a Polk County disorderly conduct case. Big reason for that is there's a huge gap in his state criminal history because he served a very long federal prison sentence related to a drug conspiracy. This case, the reason I'm asking for the high cash bond has primarily to do with his state as well as what the actual conduct was at the scene. There's body cam in this case that depicts officers arriving at scene at a residence on a domestic call. The residence they're approaching has a small deck that kind of just goes around a single door entrance. It's like a split level where you go up a staircase, but it's a very long staircase. So it's almost like it goes straight to the second floor. The victim of the domestic comes out, tells police he has a knife. From the body cam, you see the officers approach the door. They see Mr. Sonnenberg at the top of the stairs. Mr. Sonnenberg charges down the stairs. Officer Zajac braces against the outer storm door, which is one of those flimsy kind of doors. It's got two window panes right there in the middle. He braces against it as Mr. Sonnenberg crashes against the door. Mr. Sonnenberg then tries to shoulder his way out of the door. You can see through the windows in the door, Mr. Sonnenberg is holding three items. He's holding two knives and a flashlight. Mr. Sonnenberg is seen on the body cam adjusting his grip, making it so that in his left hand, he has a knife where the knife is coming straight up like that. And the right hand, he adjusts it so the knife is going straight down, flashlight straight up on the right hand. He then tries to stab through the window towards Officer Zajac. The knife isn't aimed towards the center of the pane. Officer Zajac's head is close to the window pane on the weather door. It comes within, I'd say, centimeters or inches, but does not get through the glass. Officer Zajac retreats after Mr. Sonnenberg tries to stab through the door. Mr. Sonnenberg charges out the door, dual fisting the two knives when officers fire upon Mr. Sonnenberg. Mr. Sonnenberg is so intoxicated at this point that he can't identify to officers where he was shot when they're trying to administer first aid. When the officers asked why Mr. Sonnenberg was doing what he was doing, he said he just wanted to die. He makes statements indicative of wanting to commit death by police. The domestic victims also make statements that he said he's wanted to do that in the past before. The state is of grave concern here because one, this came so close to causing great bodily harm or death to Officer Zajac. Two, the state that Mr. Sonnenberg was in with the intoxication. When they talked with the person he was with prior that evening, how much he drank, she said he drank 2 liters of vodka before heading there just that day. The domestic angle is highly concerning. This victim has been a victim of domestic violence with Mr. Sonnenberg in the past. He wasn't even supposed to be there. There was a restraining order. That's why she called the police initially. That's part of the charge there. With the domestic angle, with the high level intoxication, with the aggressive instant act of violence towards law enforcement, I think the high cash is necessary to protect the community. Thank you.
All right, Mr. Sonnenberg, I'm now going to turn to you. You have an opportunity to argue to me against what Mr. Schmidt has argued for bond and bail. So is there anything that you would like me to know?
Yeah, I do not remember, but I drank a half a gallon of vodka, and I don't usually do that. That was my first time ever drinking vodka like that. I usually drink teas, but when I get into it with my family, I intend to take myself out and self-indulge. And I know that's not right because I need help, you know, and I don't know, I'm not the one to ask for help, but now I know that I need help because I'm here. Otherwise I could have died, you know. I don't remember none of that. All I remember is thinking that her cousins were coming over. Her cousins be shooting guns next door, the little guys. That's what I thought had in my mind. But in time, in court, my sisters and my family will come tell you that I try to ask for help because I call on myself. That's why I got priors to calling on myself to have the cops come because I feel safety. And that's why I got priors in Polk County, because in order for them to let me inside, they had to charge me. And I didn't care because that's what I thought. My life was in danger outside of here, you know. But what my dad and them guys said to me, you know. And I haven't had help with my mind from my 2006 accident because I got lacerations and I had a head injury in 2006. In 2007, I go to jail. In 2008, I get indicted to 17 years. So I never had the proper things to go with my mind. And when I get drunk, I go back to a mentality like I'm in a cell again, back to USP Florence. And that's where my trauma happens. In the USP Florence, the natives give you knives to hang on because that's the part of life in there. and that's embedded in me, because that's how I had to live. And I don't intend to hurt nobody. I just hurt me and my daughter, you know. And back in the day, I'm labeled already. I got charged for attempted murder back in the day, and I was the one that got stabbed. You know, then they took my brother because he was eating a hot dog and a ketchup dropped on his boot. They took him too for attempted murder. It went from attempted murder all the way down to disorderly conduct, time served. So I'm labeled out the gate, still labeled. When I was getting out the hospital in Ramsey County, I didn't know they're coming and they're calling me a cop killer and they're pushing me. And I was like, man, I can't barely walk. You know, it's on recording. But when I get down here to booking, I take 5 steps and the booking officer says to go take your scan or whatever. And he makes the remark saying, oh, sorry, we jumped the gun. You know what I'm saying? And I was like, why would you say that to me, man? You know what I mean? He's labeling me. So I'm always getting labeled, but I haven't had the proper help to go seek my damage to my dome. And then
And at a bail hearing, you have the ability to say anything that you want to say. I'm just going to caution you now because you're going from your past. Now you're going into the actual incident itself and the things that happened afterwards. And I want to caution you because anything that
Okay.
you say in here can be used against
Sure,
you
sure.
in the case against you. Okay.
Sure.
Not that I'm saying that you've said anything that,
Incriminating.
is incriminating,
Sorry,
correct?
Honor.
But you're correct, though. All of this is on recording, or most of it should be on a recording, and it will be watched. There will be a full investigation into everything in this case
Yeah.
on both sides. But with regards to this matter, the state is asking for $50,000 cash bail with certain conditions. All right. And so that's why we're here today.
Okay. Can I get like a signature box so I can go get medical help and then go to treatment and then go get how you say that?
Mental health evaluation.
Yeah, psych
Yeah,
eval.
a psych eval. Okay, I understand where you're coming from. First, where I want to say, you say the USP Florence. When you're talking about that, you're talking about the federal prison, correct?
Sure.
And that's what you're talking about. You're not talking about serving in any military service, and you're not talking about having a weapon that you were provided and having PTSD from anything of that type of situation that where you provided any service. You're talking about when you serve your sentence in
Prison.
federal prison
Yes,
and
sir.
the things that happened there. There could be PTSD from that, but that was from your actions, your conduct, your behavior that put you in that federal prison.
Yeah.
Correct. Okay, that's just what I wanted to state and make sure that I was getting that correctly.
Yeah.
Now, you've asked for a signature bond and you do have medical conditions. You were shot in the process of this incident. There are other facts and there are other things, and there are quite honestly a whole lot of things that I'm not aware of. I'm only aware of the very basic things of the case that have been provided in the criminal complaint and in the initial warrants that have come in front of the court, the arrest warrant and the initial search warrant, and now additional information that has been provided by the state. And there have been some facts and some other information that you have provided here today.
Yeah.
Per cursory view of this, just having this in front of me, very serious. This is an extremely, extremely, extremely serious matter. From start of your incident and behavior to the culmination and the end of it, and where you sit here today, right there in orange, handcuffed to a wheelchair. All right. So it's very, very serious. And yes, part of bail is to assure your appearance for court, to make sure that you come to court and you're going to come to court. You don't have an extensive failure of appearance record. You did miss court in 2023. And I do recall you coming back right when you were back from federal prison. quite honestly, it was what, like flip, and you were here in my court for something I don't recall, and then you've been back here again. I don't know how many times, 5 or 6 or something, since you were released from prison on other matters, not as serious as this case. So I have to look at other factors and other things. And now, especially with the change in the Constitution and what I have to look at with regards to bail, again, very serious. I have to look at this case and I have to look at ensuring safety. So here, I do believe that 50,000 cash is appropriate in this matter right now. 50,000 cash is appropriate. No contact with the victims or residents. Absolutely no contact. No calling, no texting, no messaging, no third-party contact, no Instagram, no Facebook, no telegraph, no telecommunication, no things through the air, nothing, absolutely no contact with the victims or the residents here. And that would include the law enforcement officers involved, unless it's contact through their profession, okay? So that includes the victims in the initial incident and their residents, as well as then the law enforcement officers involved. But with the law enforcement officers, no contact except if it's related to their professional capacity, all right? Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, absolutely none. You may possess none, you may consume none. You may not go into any casinos, no taverns, no liquor stores, no bars, no establishments that have the primary purpose for the sale or the service of alcohol. All right. And right now, where are you living? Where's your real residence? Where do you live?
I stay with my dad or my sister.
Where's that?
Autumn Lynn Sonnenberg in Round Lake community, or my dad Bruce Sonnenberg in Maple Plain community.
And
I don't know the address.
but that's not in Burnett County, right?
No.
So absolutely no contact with Burnett County, all right? No contact with Burnett County unless it's court related. Court related or probation, extended supervision related, all right? Can't come in to go to the grocery store. Can't come in to go to drive through to go to the cities. Gotta avoid it. No contact, all right? Unless it's court related.
I fear for my life here because of the cops.
I understand, and I get that. So that's great. So this condition, no contact, great for the public, great for you. No contact, all right? Unless it's court related or probation related.
Can I get a change of venue?
No, can't do that. Can't do that. But you can talk to your attorney. So you're going to need to apply for a public defender. Do it right now. If you've already not done it, do it right now.
Yes, yes.
And this, as you can see, is extremely serious, extremely serious.
Yeah, look at me, I'm shot up, I know.
I get it. It's extremely serious. And so what you need to do is talk to your public defender. You need to apply and get appointed and talk to your public defender. And then we'll have the initial appearance and get the matter moving as quickly as practically possible, because you're going to want to get this moving.
Yeah, can I get put in for a 90-day speedy trial?
Well, you're going to have to talk to you need an attorney to do that. We can't get this moving until you talk to an attorney and you get an attorney, okay? So that's why, that's the number one thing you got to do. So I need to make sure that I can get this on a date where I can have a public defender. You're going to call and you're going to see if you qualify, but I'm going to get it on a date that I know a public defender is going to be here. So, so I can just continue to check the status to make sure you get one, all right? And to make sure we get one so we can keep this moving fast, okay? So let's get you a date and time. Our initial appearance dates and times. January 22nd at 1. January 22nd at 1. Call today, okay? Call today and tell them you need to apply, and this is very important, okay? And if you don't qualify for a public defender, let's say for some reason they say, Mr. Sonnenberg, you don't qualify, then you will need to find your own private attorney, or you have the option of considering a court-appointed attorney, okay? But that's at your cost. And you would need to have a deposit down of some amount of money, but that I need to look at your application to determine what amount would be deposited down. And it's would be a monthly payment that you would have to pay each month for that attorney. And that attorney costs $100 an hour, okay? But that's significantly less than what they normally charge, which is $200, $300, or $400 or more dollars an hour. But they're the same attorneys that agree to take these cases to give back, okay, to the community. They take it at a lesser court-appointed rate. So that's your plan, okay? So once we're done here today, you have your date, go apply for a public defender, and then you know the next steps, all right? So that's where we're gonna go. That's what we're doing here today. We are adjourned. Thank you. I will call Mr. Sonnenberg. He is appearing right now by jail, so we will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Sonnenberg appears by video conferencing in custody in Burnett County Jail. His counsel, Glenn Keene, appears by video. We're set here today in this matter for an initial appearance. Both parties, Mr. Keene requested to appear by video. Mr. Keene, were you able to go over the criminal complaint with Mr. Sonnenberg?
Yes, Your Honor, I have, would waive reading. He would plead not guilty to the misdemeanors. We're going to want a preliminary hearing on the felony. However, there's also a bond modification motion I had filed. So when the preliminary hearing would happen would realistically be based on how that goes in terms of time limits.
All right, yes, because the bond modification was filed yesterday. There needs to be victims' rights compliance, and so I need to set it out a number of days. Therefore, Ms. Bauer can have the time to notify any of the victims. Let's set a prelim in person, and you want it within time limits?
Yes, Your Honor, and like I said, depending on the time, would like to try and get the bond hearing ahead of
Yes.
the prelim, obviously. Okay.
Oh, not ahead. It'll be on the same date and time.
And that was gonna be what I requested, because for either one, I'd want to play body cam footage for the court.
Well, this court don't play it that way. This court is efficient. One hearing for both.
No, that's what I'm saying. That's
Yep.
what I'm requesting.
That's what, yep. So what we can do is, how about it would be in person. I can do January 28th. Would you be able to do January 28th at 10:30?
Yes, Your Honor, and I would be there in person because I have,
Block it all off. All right, January 28th, 10:30. We will see you then. We're setting it for both prelim and bond modification request. Ms. Bauer, please notify victims.
Yes, Your Honor.
Thank you. We are adjourned.
Thank you, Your Honor.
We will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. The state appears through District Attorney Kevin Schmidt in person. Mr. Sonnenberg appears in person in custody with counsel Glenn Keene. We're set today in this matter for a preliminary hearing and a bond modification request. I've been informed that this is a waiver of a preliminary hearing. Is that correct, Mr. Keene?
Yes, Your Honor.
And we are in victims' rights compliance. Victim witness coordinator just walked into the courtroom. Mr. Sonnenberg, your counsel advises that you wish to waive the right to a preliminary hearing. Is that correct?
Yes, Your Honor.
And he fully explained to you what it means to have a preliminary hearing. Is that correct?
Yes, Your Honor.
the burden is on the state to prove a felony was probably committed, and it was probably committed by you. Do you understand that?
Yes, Your Honor.
And do you understand that by waiving your right to a preliminary hearing, that means that you understand and you agree that the state can at least meet that burden? Do you understand that?
Yes, Your Honor.
You understand that at a preliminary hearing, your attorney would have the ability to ask questions of the state's witnesses, to call witnesses to testify for you. He would also have the ability to present evidence on your behalf or possibly discover things about the case, which could include defenses. But for today's purposes only, and for this hearing only, you'd be giving up those rights. Do you understand that?
Yes, Your Honor.
And you understand that for this hearing only, that if the state would not meet its burden as to the felony, I could reduce it to a misdemeanor or dismiss it altogether. But you would be giving up that right today?
Yes, Your Honor.
Do you understand that as a result of waiving your right to a preliminary hearing, that means that this matter will be bound over to future proceedings, which could include a trial? Do you understand that?
Yes, Your Honor.
You also understand that once you give up the right, it is forever and you cannot get it back.
Yes, Your Honor.
Has anyone made any threats or any promises to you other than any offer presented by the state for you to waive your right to have a preliminary hearing?
No, Your Honor.
You're doing so freely and intelligently. That means you're telling the court that you fully understand what you're doing here today
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
As you're, I don't need to go there, sorry. I will find that you're competent to freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the complaint.
Would you like to proceed with an arraignment today or set for another date, Mr. Keen?
I'd like to proceed now, Your Honor.
He understands those charges and the maximum penalties,
Yes, Your Honor, and he would plead not guilty.
and he waives former reading, pleads not guilty. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I don't have an address right now. I believe you said that you have a relative in either Sandstone or Hinckley, or that's where you would be going?
No.
Oh, I thought that's what you had said.
In Maple Plain, my dad,
Maple Plain,
in Round
your
Lake,
dad.
my sisters.
Do you know that address? Because we don't have any address on file for you.
I don't know the address of Maple Plain because he just moved from Round Lake to Maple Plain and then
All
went
right,
to a new
okay.
house.
I was just curious to try and update the file for, just for purposes. I have a motion filed by your counsel requesting the court to consider modifying bond. Mr. Keen, I have reviewed and read your motion. I will now allow you to argue those facts on the record.
Thank you, Your Honor. As you know, when you look at bond, some of the conditions are protection of the community and to ensure appearances. I would note that Mr. Sonnenberg, even if you believe you are dangerous to me on a regular basis, note that he currently is dominant hand is, in a cast, and he's recovering from multiple gunshot wounds. I would note that the last, because he had been in custody in the federal system for a long time, but the most recent case we can deal with in Sawyer in this county, 24 CM 49, he did make 3 or 4 appearances. The one he didn't appear at was excused after input from his attorney. I don't know what the circumstances were. And
Circumstances where the court wanted to just get the matter resolved and heard from, I believe his attorney was Michael Paul at the time.
Yes.
And just quite honestly, it was a less serious case and just wanted to keep the matter moving.
Okay. I didn't know if Attorney Paul stated some excusable reasons for the record. Okay.
Well, the court just wanted the matter moving.
All right. Well, in this case, I would note that Mr. Sonnenberg is seeking residential treatment for substance abuse and mental health. We don't have a report from Koinonia or admission with Ms. Hildy simply because he has not been able to get a Zoom appointment. The jail policy, after talking to Lieutenant Mogen, is that they're overwhelmed with Zoom appearances, so they'll only grant them if there's a chance they may be successful. So what I'm asking the court to do is conditionally lower bond to a $25,000 signature bond from the current $50,000 cash bond, because, and the conditions would be that, for the reduction would be that, the treatment provider or LCO with, presumably Ms. Hildy, the tribal opioid response manager, would provide on official letterhead to the clerk of courts proof that Mr. Sonnenberg is admitted to a inpatient treatment facility and would be supervised. And then that condition would not apply until the jail, it would also require the jail to verify that, satisfactory transportation arrangements have been made to ensure that he gets there versus just, Mr. Sonnenberg, here you go. And that if Mr. Sonnenberg leaves or is discharged from Koinonia or a different treatment center they may find, that his conditions of bond would return and Mr. Sonnenberg would need to return back to the custody of Burnett County on his $50,000 bond. I mean, unless he was were able to miraculously come up with the $50,000 in cash. Would note that Mr. Sonnenberg has been in custody since January 3rd. He's informed me he's not able to, provide any meaningful amount of bond. And when you look at the conditions of bond, it's to ensure appearances. If he's in a treatment facility, they could arrange Zoom or other means to ensure that he appears for court. This also provides protection for the community because, again, Mr. Sonnenberg would be at a residential facility that does have 24/7 supervision. And Mr. Sonnenberg would also be in a position where if he chose to leave it or were discharged, he would have to return promptly to the Burnett County Jail, or else he would be facing a potential additional charge of charges of felony bail jumping. And so we're not asking for Mr. Sonnenberg in these serious charges to just be, off to the races and free with no supervision and no concerns for protection for potential of alcohol or other items. I believe, I do believe that the bond motion provides for the protection of community court has to consider, and Mr. Sonnenberg's, potential danger to community is obviously, lower than would be on for anyone on a normal basis because, again, he is recovering from multiple gunshot wounds, and without transportation, he's likely to stay where he's at. So, would ask the court to grant the bond modification that would be contingent upon providing the treatment, and that would allow the jail has informed me that they would allow Mr. Sonnenberg to do a Zoom arrange a Zoom with Ms. Hildy so that he could get placed in a treatment, which would be, for his own good as a citizen as well. But, they're not going to schedule a hearing if his bond is still at $50,000 and he has no meaningful opportunity to raise that.
All right, thank you. Mr. Schmidt?
After the Dale Brooks case, the legislature passed a constitutional amendment that directed courts to look at something else. When someone's charged with a violent offense, the court can look at other past violent offenses and a criminal history and set needs based upon that for protection of the public. When I look at Mr. Sonnenberg's record, I see something of a pattern of violence in his history. A lot of his early history in the 2004 to 2006 range, it's just DCs. There is one case involving actual injury that was an OWI causing injury in 2005 in Barron County. In 2006, he was first convicted of selling cocaine in Barron County. Read into that case was a substantial battery. 2006 Washburn, DC with another battery read in. And then he had his federal prison case, which was a large crack cocaine conspiracy in the St. Croix tribal lands. He had a 17.5-year sentence on that. After getting out of prison, he had a Washburn 2021 case with crime damage with burglary dismissed but read in. Another OWI, then Polk County in 2023, a DC with a battery read in, and then our Burnett County, a DC with a battery read in. He has 2 other open cases right now, both in Polk County, both are DC with repeater. I see that in the recent past, he's again behaving erratically. This case itself involves erratic behavior, charging the police after being at the home of MM in violation of a restraining order. I think the biggest problem I see though is the fact that one of the allegations here is just him violating the restraining order, and he's on body cam inside the house he's not supposed to be at. I can't fathom why we would conclude a signature bond or a lower cash bond would have any effect on Mr. Sonnenberg when a restraining order that was only issued in September of last year didn't deter him. I think that there's a real serious risk of death or great bodily harm to MM if the court reduces bond or releases him on a signature bond. I don't think inpatient qualifies as supervision for Mr. Sonnenberg because it won't stop him from leaving or walking away. They're not going to physically restrain him. The danger still exists there. The maximum penalty on this case is very severe. With the repeater, it's 17.5 years just on count one, just like that federal sentence he was sentenced to. I think if anyone knows how terrifying that amount of exposure is, it's Mr. Sonnenberg. He has a lot of reasons to walk away or hide from this case. I think that should give the court pause about likelihood to appear. I think the court should have even greater concern about danger to the public. Thank you.
All right, thank you. Hearing the arguments from both sides and in review of at least the allegations that are stated in the criminal complaint that do rise to at least probable cause, this is a very serious case and the court does need to consider protection of the public and here at least protection of the victim because there is a potential for serious risk of great bodily harm. And as it was pointed out, if a piece of paper, an injunction could not stop Mr. Sonnenberg, there's no guarantee that putting him into an unarmed, unmanned treatment facility would protect the public. So the court at this time is going to deny the request for bond modification and will keep it at $50,000 cash. So let's get another date and time so that we can come back to court and we can see where this matter is going and if we need to set it for trial.
Yeah, my client's indicated that he wishes to exercise his rights to a speedy trial now that the information has been filed. It's now timely, and the defense has filed the discovery motion. So,
All right.
He's-
So, Mr. Schmidt, how many days do you think that we may need for a speedy?
It's 2 on the edge of 3. So I would say 3 to be safe. One of the things that's going on is we're waiting to get like medical records of Mr. Sonnenberg.
And do
So
we need lab?
we might, his blood was sent to the lab. We don't have results yet.
Let's just schedule without lab right now. And hopefully we won't need lab because if we don't have results, we don't have an analyst, then we know that this is speedy and hopefully they'll be able to accommodate.
Yeah.
For now, we are requesting a speedy trial. The court has conferred with deputy clerk as well as assistant to find 2 full days to have a jury trial in this matter to meet speedy trial. We can do April 3rd and 4th. That works with the calendars of Mr. Keene as well as the court. This will be a number 1 for the court, and the court has another jury trial scheduled for that date and time, which will now be a number 2 because speedies do take precedence. So we will have this scheduled for April 4th and 3rd, April 3rd and 4th. Now let's get a final drop dead date. That means I will accept no other agreement past this date and time. So, Mr. Sonnenberg, it means that if you do not reach an agreement, you do not reach any type of resolution by this date and time, it will go to trial for every single charge unless they are completely dismissed in entirety by the state. February 28th at 9:15, I will schedule you then. That is the final pretrial. That is the court's, again, drop dead date. I will accept no plea agreement after that date. Nothing, no reduction in any, no amendments or modifications of any charges, no agreements to any sentencings, nothing beyond that date. It will either be after that date and time. If there is a resolution after that date and time, it would be plead to all of the charges as charged and proceed to sentencing or dismissed in entirety. Otherwise, the matter goes to trial. Is that understood?
I don't recall the schedule. Will February 20th then also be the deadline for amending upwards on the information?
Yes.
Okay, thank you.
Well, I mean, technically, that's not what case law says. But
The
case
court
law,
can control. Yeah.
yes. But yes,
Thank you.
thank you. We are adjourned.
Thank you.
We will go on the record in the matter 24 CF 252. Wait, before I go on the record, be a young little child.
My client's daughter, she's 6.
I presumed that. This is very serious. And it could involve a lot of things said. And I wouldn't want any negative things or things said potentially that could harm or hurt her opinion of her father and her mother or anyone involved. You're the mom. What do you think? This will be a while, but I know that you were involved. She was as well. I just have a fear of court cases, especially serious ones impacting children. Okay. We will go on the record in the matter 24 CF 252, State of Wisconsin versus Andrew Sonnenberg. This date appears through District Attorney Kevin Schmidt in person. We have Renee Landgraf, Defense Counsel in person. Mr. Sonnenberg appears in person in custody. We're set today in this matter for the sentencing portion of this case. Mr. Sonnenberg pled guilty to first-degree recklessly endangering safety, a Class F felony. The other matters were dismissed and read in for purposes of sentencing. The court ordered a pre-sentence investigation report. The court has reviewed that report. Defense ordered an alternate pre-sentence investigation report. The court has also reviewed that report. I need to briefly look to see if I wrote down anything that jumped out to me as being a material mistake or fact. I don't notice any. All right. This matter did involve a last minute after the plea competency review. The court during that review did find the defendant competent and able to proceed to sentencing. So we're here today. Victims' rights compliance.
We are.
All right, we're in compliance. We're going to have 2 victim impact statements. Before I begin, Mr. Schmidt, did you receive both of the pre-sentence investigation reports?
I did. I have no correction to the court's PSI.
All right. And I know Ms. Landgraf did as well. And as it relates to the defense's PSI, there are certain corrections that Ms. Landgraf has filed with the court. Ms. Landgraf, did you review both of these documents with Mr. Sonnenberg?
I did, Your Honor. The document that I filed yesterday has the minor corrections to both PSIs.
Okay. Oh, to both. Yes, that's right. To the DOC PSI and to the alternate. I did review that yesterday, so I was aware of that. I apologize for misstating. And you thoroughly reviewed those with Mr. Sonnenberg?
To the best that I could, yes, Your Honor.
All right, to the best that you could. So you did all that you can as a defense counsel to be able to go over the documents with Mr. Sonnenberg?
Yes, it was a very emotional process. So we had to take some time and to get through it. Instead of just reading word for word, I kind of translated the paragraphs into my own words to let Mr. Sonnenberg know what was being conveyed.
All right, and for the record, you are a very experienced attorney, very good at your job, and in certain aspects, you do that as well with the plea question and waiver of rights. That's your own form, your own computation of that, but it has always been accurate and correct in the court's view of when you have done that. Mr. Sonnenberg, I know that this is an emotional day for you. It's a serious day for you. Did you have enough time to go over both of these documents with your attorney?
Yes, Your Honor.
And did you understand what these contain?
Yes, Your Honor. A little bit, yeah.
Did you find were there any material facts or anything that was wrong that you want to correct to the court other than what Ms. Landgraf has filed?
No.
No, all right. And I'm gonna say, Ms. Landgraf, if he is going to make a statement, I will need that microphone down because it's hard to hear him. There we go. All right.
We don't need to do that until you actually type it.
Off the record. Is he not handcuffed?
No, he's got a brace on his arm. We don't have handcuffs.
All right. I'm sure it's a situation that we have a lot of enforcement here, that if something were to go awry, then we are here. All right, back on the record. Okay, so let's start with the first statement, Ms. Bauer. Who is going to come and make a statement?
That black desk.
Off the record again, I would feel more comfortable if we had a law enforcement officer on that side as well. Thank you. Thank you, Captain. Back on the record. Please state your name and spell it for the record.
Colin Gerald O'Toole, COLLIN GERALD Toole.
All right. Officer O'Toole, if you would like to, please present your statement to the court. And if you're reading something, please read it slowly so that the court reporter can take down everything. And if this is going to be emotional for you and you need to stop, that's fine. I'd rather have you stop and take a breath than to not understand what you're saying.
Okay.
Okay?
The first one will be for Officer Zajac, who couldn't be here today. Your Honor, on the evening of December 16, 2024, my life could have been taken from me. On Monday, December 16, 2025, at approximately 5:55 p.m., I was nearing the end of my shift. It had been a long day, and I was with Officer O'Toole, who was in phase 3 of his field training. We had just cleared the Burnett County Jail after handling another incident and were heading home for the night. As I pulled into my driveway, a call came over the radio, one that instantly made my heart sink. It was from St. Croix Tribal Dispatch, relaying a 911 call that had came in at Burnett County Dispatch. Raina LaPointe, the mother of Monica, said Andrew was drunk and had locked Monica in the bathroom. He wouldn't let her out. I knew Andrew. I knew his history. I knew what he was capable of. A man I knew from prior violent incidents. Monica had a restraining order against him. I knew he was capable of harm. I knew she was in danger. And I knew that if I waited or checked off duty, as I was just minutes from doing, someone could have been hurt or worse, killed. What happened next changed the way I will respond to calls for the rest of my life. Monica had a protection order against him for a reason. He's a big man, aggressive when intoxicated. And Monica is significantly smaller, far more vulnerable. My instincts told me there wasn't time to wait. There wasn't just another domestic call. This was a situation that could turn deadly if we didn't act fast. I pulled out of my driveway and responded emergent. I wasn't going to let Monica become another name, another statistic, another woman failed by timing and hesitation. At 6:02 p.m., I arrived. A familiar sedan was parked in the driveway, Jamie Long's vehicle. She was sitting inside. As I walked past, she looked at me with wide, anxious eyes and said the word I'll never forget. Andrew's inside. When I arrived on scene, Officer O'Toole, my trainee, was right behind me. As I approached the split-level home, I saw Monica standing in the foyer, terrified. The front door was wide open, and I could hear crashing, yelling, and chaos inside. Then the words no officer wants to hear. He's getting a knife. Seconds later, I saw Andrew sprint up the stairs into the kitchen, and then the crashing grew louder. He was tearing through drawers, and I knew exactly what was coming next. I secured Monica out of the house and turned to confront what I feared would be the final seconds of my life. Andrew came charging down the stairs, full sprint, straight at me, wielding a large kitchen knife. The only thing standing us was a storm door, already damaged, the latch broken. He began slamming the blade against the glass. Full force strikes, not tapping, not threatening. He was attacking with the clear intent to kill me. Each time his knife hit the glass, I braced for the pain to shatter. I could see the rage in his eyes, not fear, not confusion, just raw, violent rage. Inches separate that knife from my body. I gripped the door with everything I had, knowing that at any moment it could give way. I tried to de-escalate. I tried to speak to him. There was no humanity in his response, only aggression. He was out of control. He was focused on ending my life. In that split-second moment, with a weapon pointed at me and no barrier worth trusting, I had to make a decision, use deadly force or try to reposition. I looked behind me and saw something that stopped me, ran of the point, and a child near the stairs. I knew if I pulled my weapon and fired, I might hit one of them. So instead of protecting myself, I risked myself and I retreated to move to a tactical position. And just as I did, Officer O'Toole discharged his firearm, saving my life and possibly others. Afterwards, I helped render aid to Andrew because that is our duty as officers. But it does not erase what happened. It does not take away the fear, the trauma, or the reality that I came within inches of being stabbed to death while doing my job, while protecting others. This wasn't a mistake. This wasn't a misunderstanding. Andrew Sonnenberg made the choice to turn a residence into a battleground, to turn a knife into a weapon, and to try to take a life that night, mine. Since then, I've struggled with the psychological toll of that encounter, the weight of having to make a life or death decision in a split second, the memories, that knife slamming into the glass, the look in his eyes, I still hear it, I still see it. I ask you to understand I wear a uniform, but I'm human. I have a family. I have people who expect me to come home. And on December 16th, at approximately 40 seconds after arriving the scene, that was nearly taken from me by one man's violent and deliberate actions. The hardest part of the whole situation was it was a normal shift that day. I was just pulling into my residence, getting ready to see my family when I backed out of my driveway. I can't help but think I didn't call my wife or my kids when doing so. And if I got killed that night, the last thing they would have heard, the last thing they would have seen was my squad leaving the driveway after pulling in. No goodbye, no I love you, nothing, just taillights. The part that hurts the most, knowing what they would have felt, they would have had a lifelong sadness that wouldn't go away. They would always have those questions of what if, hold him accountable, not just for what he tried to do to me, but for the chaos, the trauma, and the danger he brought into that home that night, to Monica, to the child, and to my family. I'm asking, no, I'm pleading for you to impose a maximum sentence allowed under law. Andrew didn't just break the law that night. He broke a woman's sense of safety. He shattered trust, and he showed complete disregard for the protection order meant to keep Monica safe. His actions were calculated, violent, and terrifying. Monica could have been seriously injured or worse. The fear in her mother's voice, the scene we walked into, the trauma that Monica will carry, none of it will be undone. He was proven time and time again that he's a danger, and to anyone who tries to protect her. The only way to ensure Monica's safety and to send a message that this kind of abuse will not be tolerated is to hold him fully accountable. Please, Monica, please, for Monica, for her family, for every victim who prays for the protection that comes too late, give Andrew the maximum sentence. He earned it. Officer Mike Sajak, badge number 435.
Thank you. Now, Mr. O'Toole, yours, please.
Yep.
And again, if you need to take a second, you may do so.
On December 16, 2024, a day that changed everything. It's my first day of
I'm
phase.
just going to ask you to slow down a little bit.
Okay,
You read Officer Zajacs, very slow.
okay,
And good. So please do that with yours.
thank you. A day that changed everything. I was in my first day of phase 3 FTO. I was so new that I didn't even know if I had my badge on correctly. At 6:02 p.m., my career changed, my family changed, I changed.
Take as much time as you need. It's a little bit more difficult, I'm sure, reading your own versus somebody else's.
I was on the phone with my wife when the call of domestic in progress came out. I told my wife that I loved her and I would be home soon. Never did I think that was almost the last words I'd ever tell her.
Officer O'Toole, you may take your time.
Never did I think I wouldn't be able to tell her I was okay, how much I loved her, or how I almost didn't come home. Being so new, I showed up to the wrong address. I thought I was going to get made fun of for it. Little did I know that mistake most likely saved my life. Mike and I arrived at the same time, hearing screaming of "he's got a knife." When I noticed Andrew coming down the stairs, knife raised above his head, coming for Mike and I. My only thought going through my head was my family and my partner's family. How could I explain to them that I failed in doing my duties of keeping my partner safe? I couldn't let that happen. Andrew, even as you were laying on the ground, you still showed no remorse, no care, no regret for what you were putting your kid and family through. You will never change. You refuse to take accountability for your actions. If it wasn't for Mike's bravery of holding the door, even in the face of imminent death, everything would have been different. If it wasn't for my first FTOK teaching me and preparing me for my career ahead.
I'm going to guess by FTO, you mean field training officer?
Yes, my field training officer, Kate Barker. Teaching me and preparing me for the career ahead, everything would have been different. If it wasn't for me going to the wrong house, everything would have been different. Even though I protected people and did my job and came home, it has not been without its challenges. I've spent many sleepless nights replaying the night of December 16th in my head and wondering what my future would look like. My family and I have shed many tears over an avoidable situation that could have costed my life or my partner's life. When people say life flashes before your eyes, I never believed them until that day. What I saw that day was my wife holding hands with a little girl I knew if I didn't stop Andrew, I'd never get to see this future with my wife. I believe that was God telling me what he had planned for me. When I was at my lowest, I told my wife I couldn't see through this, and she asked me if I could see my next step and said, just take it. I will be there to catch you if you fall. That's what true love is. That night, I had to start my recovery journey. Through that, I got adopted into a new family, the law enforcement family, a family that checked on me continuously throughout my journey of coming back to the job, a family that has my back until the very end, a family that never let me be alone in my darkest hour. I can't thank the Burnett County Sheriff's Office, St. Croix Tribal, Siren, Webster, and Grantsburg Police Departments enough for their continuous support in my journey. Holly Hakes has helped me ground myself and the support that I've received and focusing on the future ahead. I'm not leaving. I'm not going anywhere. This is where I belong. This is what I'm meant to be. I would do it all over again for my brothers and sisters in blue. I will keep doing it because it's my job to make sure everyone goes home safe. In the words of Mark Peterson, in the end, all that matters is I did the right thing. All I ask is that justice be served in a way that reflects the seriousness of what my family and I endured. Thank you.
Thank you, Officer O'Toole. All right, Mr. Schmidt. Argument and sentencing recommendation, please.
Thank you. A segment in here, I'm going to switch to playing some video footage for the court. I'll let the court know when I'm going to do that. I've already set it up with the clerks prior to the hearing.
Thank you for doing that.
The state's recommendation here is going to be towards the high end of the court's PSI recommendation. I'm going to be recommending 7.5 years initial confinement and 4 years extended supervision, which is the top end of that.
All right.
The driving factors of my recommendation are, I think, in order that I think the court should prioritize them, which is incapacitation, specific deterrence, rehabilitation, and general deterrence. I think it's most appropriate for me to start with my argument based off of the presentation by the officer here, reading Officer Zajac and Officer O'Toole's statements, by emphasizing how really dangerous this offender is. You heard some of that alluded to by Officer Zajac's statement. His criminal history is just riddled with either dealing convictions or battery convictions or read-ins. Most people who were talked to by both PSI writers, both the one who prepared the sentencing memorandum for the defense, as well as the DOC agent who prepared the courts, referenced multiple incidences across Mr. Sonnenberg's life in particular, where Mr. Sonnenberg was in possession of knives and a need to disarm him. That's been like a recurring thing mentioned in those PSIs. The instant case involves him stabbing at and chasing 2 police officers before they really even had a chance to say much of a word to him. It was just wanton and pointless and potentially lethal. That's where I should start with it, the actual fact pattern here and the dangerousness of it. 2 tribal police officers were called with what initially sounded like a domestic call, an unwanted person call, a violating a restraining order call. You've heard some description of it already. As they approached the building, dispatch warned them over their radio of an ongoing shouting and crashing in there, as well as mention of a knife. As they approached the front door, Monica Martinson left the residence while warning the police that Sonnenberg was getting a knife. As she exits, when you watch Officer Zajac's body cam, Andrew Sonnenberg is at the top of the stairs with both knives in his hands, 2 of them. Officer Zajac closes what I think could be fairly characterized as a rather flimsy storm door as Sonnenberg barrels down the door or down the stairs and charges at the door and collides with it with full force and the momentum of charging down a flight of stairs. He changes his grip on the knives to get a firmer grip on the largest knife and to adjust it for downward thrusts towards the glass pane of the storm door. He swings in particular directly in the direction of where Officer Zajac is behind the door, bracing it with his foot to prevent it from opening, to prevent Mr. Sonnenberg from gaining access to himself as well as to Monica, who had just left the building. Zajac moves back from the knife thrust, moving back from the door, and immediately Sonnenberg bursts through the door with both knives, one in each hand, charges at the police, and is quickly stopped by the fast actions of Officer O'Toole. Because there was so much talk about this incident in the PSI, that's why I think the court really, to understand the dangerousness, as well as I think the fastness of it, how much happens in such a fast period of time, I'm going to need to play it for the court. I'm going to be playing the segment of this from both Zajac's perspective as well as O'Toole's. It's going to be less than 1 minute of video from each of their body cams. That's how much happened in such a short period of time. When we do suppression motions, when we analyze constitutional issues, something the Supreme Court really tells us is to consider the fast need to respond and make a decision, the snap judgments law enforcement needs to make for safety reasons every day. And I think this really emphasizes why that exists, why that's a matter of law and not just a matter of fact. I want the court to watch for the things I just described. I want the court to watch in particular for this one. So I'm going to start that now.
Before he does that, my client would like to leave the courtroom for the video playing.
There's a,
All right, I do have to require him being here for the sentencing portion, but for the video portion, does that go into your argument? Do you talk while the video plays, Mr. Schmidt?
I was going to.
Can you refrain from doing that?
What I'll do then is I'm going to play each of their videos twice and then I'll comment later. The reason I'm playing it twice is just it's so much so quickly.
All right. Law enforcement comfortable with that and bringing him to the elevator or elevator room? All right, thank you. Then we can remove Mr. Sonnenberg for the playing of the video portion only on his request. What?
Do you need me to get it? No, do you need me to get a presentation thing?
I think I can do it. We don't do it a lot, but okay, so should be on.
Perfect.
Yeah, I know. Okay.
I hear a lot of screaming on the phone.
Get out of the house.
She
Yeah.
says he's grabbing a knife.
Hey,
Oh my God.
Andrew, stop. Just, hey, stop. Want a gunpoint?
One more time.
I'm in the house with Monica.
Yeah, I know. Okay.
I hear a lot of screaming on the phone.
Get out of the house.
She
Yeah.
says he's grabbing a knife.
Hey,
Oh my God.
Andrew, stop. Just, hey, stop. Want a gunpoint?
I hear a lot of screaming on the phone now. She's busy grabbing a knife.
Mike, you hear that? Oh my God. Hey, get out. Andrew, stop, stop, stop. Just, hey, stop. One at gunpoint, one at gunpoint. Shots fired, shots fired.
I hear a lot of screaming on the phone now. She's busy grabbing a knife.
Mike, you hear that? Oh my God. Hey, get out. Andrew, stop, stop, stop. Just, hey, stop. One at gunpoint, one at gunpoint. Shots fired, shots.
All right, can you knock so they can come back in?
And then just for the record, I played the first 44 seconds of Michael Zajak's body cam. I played it twice. For Officer O'Toole's, I played the first 26 seconds twice. That's going to be on a flash drive. I do submit to the court at the close of my sentencing argument.
Right, thank you.
When I watch that body cam footage, a number of questions race across my mind every time I watch it. First, what if Officer Zajac did not retreat when he did? What if that storm door panel, that flimsy glass there, what if that broke? What if Officer O'Toole did not fire and also chose to retreat? Would they have been running away from Mr. Sonnenberg? Would they have gotten away? What if the police were 5-10 minutes later on arrival? Would Sonnenberg have gotten out the knives anyways with Rana and Monica? He has a history of violence, in particular with Monica. With what Mr. Sonnenberg consumed, according to the PSI, the vodka, the cocaine, the fentanyl, the methamphetamine, there's no way to know. I don't think he could possibly know, and that is terrifying. For Monica, for his daughter, for the police, for literally anyone in the community who might have been coming into contact with him when he was doing that. His own family has complained that they've had to disarm him of knives themselves, that this is a recurring problem with him. Just for those reasons, probation, where the court has to start with every sentencing, cannot be the answer. Andrew Sonnenberg cannot be safely in the community for treatment. So let's talk about rehabilitation here for a second, because both PSIs talk about rehabilitation a lot. There's a lot of conversation about traumatic brain injury and injuries he suffered from terrible car crashes back 20 years ago, as well about his substance abuse. He himself sources all of his violence, all of his criminal history back to substance abuse. I have mixed feelings about that in this case, because yes, he has the memory issues and the traumatic brain injury from the car crash. And yes, he's got the substance abuse issues. But when you read the PSI, both Sonnenberg and his family seem to have been very acutely aware of this. They've known about these issues for a long time, and they've persisted. And it doesn't matter how many terms of probation he's been on, how many sentences he's gotten. He's been evaluated up and down the wazoo by state and federal authorities for mental health and AODA. Decades of that kind of treatment, both on supervision and in a confined setting, has been to no avail. The awesome resources available through the federal system were not enough. They even had a reentry program, something that, quite frankly, would be a dream in Wisconsin, that Sonnenberg once failed out of and then the second time just refused to do. The reasons I have mixed feelings about the rehabilitation for this fact pattern is because, yes, you could look at Mr. Sonnenberg and say to yourself, if we can just get the right treatment for the traumatic brain injury and the memory issues, we know there are treatment paradigms for that. There's therapies, there's oversight. And if we can just treat the AODA issues, then if these really are the causes of all his behaviors, then that should work. That should end the criminal behavior. It should end the pattern of undesirable behavior. But the problem is that's what's been done for 20 years. And with it, look at that as a double-edged sword to say, it's going to work this time. Madness is doing the same thing over and over and over and expecting different results. The expectation should be, regardless of what the sentence is today, if we're just using logic and science and prediction and believing in the assessment tools, that Mr. Sonnenberg is likely to recidivate again, and it is likely to be violent because of this history, because of the history of non-success rehabilitating. And because when you look at issues like that, when a person has a 20, 25-year history of abusing substances and getting violent, it really brings to mind why in 2013 the legislature got rid of the voluntary intoxication instruction, because they just thought it was a bad idea. If you read the legislative materials for when they did that, it doesn't make any sense for a person to be alleviated from responsibility from choosing to use a substance that causes criminal behavior. Yes, there's the substance abuse disorder. It's harder for them, but there are a lot of people who are alcoholics, who are addicted to controlled substances, who don't have these issues. They don't have this level of burden on society. Because when it gets down to it on this one, the risk that, say, a drunk driver has to society is the speculative risk of maybe they'll hit someone. Or the risk of someone who is addicted to drugs might be, maybe if they have a history of stealing, they might go out and steal. The risk of Mr. Sonnenberg is different than a lot of other people because the risk is of death and great bodily harm to others, of him working himself up into a state where he can be that dangerous to people. The instant offense, the elements of the offense is literally that. It's risk, it's substantial and unreasonable risk of death or great bodily harm. That's what he did. And what caused it was him hanging out with a friend and consuming a large amount of alcohol and drugs, working himself up to violate a restraining order with his acts. That's what he was trying to do when police just arrived and he attacked them. That's why in this case, the solution has to be prison, and it has to be a substantial amount of prison. Prison is the only place where treatment can be safe for the community. Treatment is necessary in a confined setting here. I think even beyond that, I think not just treatment, I think Mr. Sonnenberg needs a controlled environment where he can't be a risk of death or great bodily harm to others, where he can practice the sobriety that's supposed to come after treatment. If he can't accomplish that in prison, he's not going to accomplish it outside. There is some suggestion in the PSI with statements from Sonnenberg and some other people that he shouldn't be sent to prison because he'll just use drugs in prison, which is really counterintuitive, because if a person is going to use drugs in prison where drugs are less available, where there's less control over, where there's less drugs available and more control over them, then they're obviously going to be greater risk of using drugs in the community. Just the instant case here involved polysubstance abuse. The community needs Mr. Sonnenberg to get treatment in a confined setting and practice that sobriety for a substantial period of time before he gets released. And prison is the place where that can happen. Because when Mr. Sonnenberg's out in the community, it's easy for him to get controlled substances, even if he were on probation. It would just be a simple drive to a liquor store or using old connections to get controlled substances. And when he uses those, he becomes unpredictable and potentially lethally dangerous to the community. Prison is a consequence, you can tell from the PSI, that is extremely negative to him, meaning he really doesn't want it. So it also has a strong deterrent effect to him. Finally, I have to speak to the gravity of the offense, which is, it's different than the other things I've described so far. I've argued for incapacitation in the sense that the more time Mr. Sonnenberg is away from the community, the more time it's protected because of the unpredictable, dangerous nature of him using controlled substances and the impracticality of preventing him from using controlled substances while on supervision. Specific deterrence, the long prison sentence, ratcheting up consequences. Rehabilitation, where it's a double-edged sword, where it seems if you could treat some of his underlying conditions, the substance abuse, the traumatic brain injury, he might be better, but the lack of success over 20 years would suggest it's perhaps hoping a bit too much to think that's likely to happen. And finally, the general deterrence, which ties into what I'm going to say about gravity of the offense. This is a person who charged the police with knives before the police had done or really said anything. The court just watched the body cam I played. The officers just arrived there. They hadn't even had contact with Mr. Sonnenberg. They're warned over the radio of shouting and knives. They hear shouting. They hear Monica leave the residence and mention knives. And Sonnenberg appears at the top of the stairs with one knife in each hand and just charges them. No discussion. No, let's talk about this. You heard Officer Zajac try to talk with Mr. Sonnenberg at the door after he charged and started slamming the knife into it to no avail. It was completely pointless, reasonless, potentially lethal violence. That demands treating this with high gravity. It might be the police were charged at because they are police. They were targeted for that reason, that identity. There's some stuff in the PSIs to suggest that. Comments from Mr. Sonnenberg about being paranoid about the police and them targeting him and complaining about the jail. Perhaps even more terrifying is the possibility that Sonnenberg would have charged anyone, as I described before, concerned neighbor, different family member, Jamie Long, who drove him there and didn't think any of this was a good idea to begin with. Someone who wouldn't have a gun with them or have training about what to do in these scenarios or not be his relative to be able to, hey, Andrew, or let's just talk it out, just give me the knife. Someone who wouldn't be able to do that. What happens if that's just a concerned neighbor instead? The risk here was above substantial. These officers, with the suddenness of what Sonnenberg had thrust them into, were clearly affected. You could see the reaction on Officer O'Toole's face. The emotion he had was raw and genuine. There's no doubt he suffered trauma from this incident. You could feel it in the words written by Officer Zajac. He was actually explicit about that. All of this came from what you have to determine at the end of the day, because we believe in freedom of will in Western tradition, a deliberate decision to consume large amounts of substances and consuming alcohol before working him up to violate that restraining order. He did traumatize the police. He could have traumatized Monica. He might have traumatized his own daughter, who was there and present in the house when this happened. Officer Cassidy, who's here today, helped come afterwards and take care of that. The gravity in this case is too much. This offender is too likely to recidivate violently. It was just nonsense that the Compass assessment said medium violent offense here. The court saw that that was not medium violent offense. The community has to be protected. Sonnenberg needs treatment in a confined setting, and he's already done so much programming that I think the goal of treatment in a confined setting isn't just to do the treatment and bounce him out as soon as possible, but also to make sure he stays there and can practice sobriety to show he's earned it. If he can't maintain sobriety in prison, he's obviously not going to do so out of prison. Finally, other people out there need to know that there will be severe consequences from attacking the police in this manner. There was no reason for this. The court saw that. General deterrence is needed. 7.5 years of initial confinement is needed. I'd ask the court to follow my recommendation. Thank you, and then I'll submit this at the end.
All right, thank you. Ms. Landgraf, I'm now going to turn to you for your sentencing recommendation and argument.
Thank you, Your Honor. I'm not going to underscore the gravity or the seriousness of the offense. I think we all know how serious this was. the defense understands that this is a prison sentence. I heard the DA say that Mr. Sonnenberg doesn't want to go to prison. He's trying to not to go to prison. That's actually not the case. During our negotiations, we actually offered to resolve with a joint recommendation for a prison sentence. Mr. Sonnenberg knows that this is a prison sentence. When I started representing him in this case, he actually refused to look at the discovery. He was very focused on his hand and the trauma that he went through for being shot, because just like Officer Sajak said in his statement that he's not just a uniform, he's a person too. Mr. Sonnenberg is not just a uniform, a jail uniform, he is a person too. It's easy to sit here and say, what if this would have happened? What if that didn't happen? If whatever happened, there would be more serious charges. There would be different charges. That's not the charges that's before the court though. Luckily, the only person who was physically harmed was Mr. Sonnenberg, and he has long-lasting effects. He's never been shot before. And he and I have spent significant amounts of time talking about how the shooting really changed his perspective mentally. This was a whole different ball game for him. I have hope and faith that this incident was so life-altering that it will have an effect to have him make the changes that he needs to make. The PSI and I believe the DA both talked about how he immediately armed himself with a knife. The PSI said that he went into prison mode by grabbing a knife. Mr. Sonnenberg was a teenager when he was sent to 12 years in the federal prison for dealing drugs in a tribal community with his family. His family was the one that was doing that. He was in and out of foster care for his childhood. He didn't finish school in his childhood. I don't know what society can expect from someone who has that kind of upbringing. He never had a role model in his family. Most of his family members, I think there were 13 or 14 of them that were sentenced to prison along with him. So he comes out of 12 years in prison for drugs. And while he was in federal prison, he carried a shank. I mean, of course, was he supposed to? No, but I don't know what goes on in federal prison, but apparently that is what goes on in federal prison. And I think we can see that clearly play out if somebody is so messed up on drugs that the first thing they need to do is grab a knife and arm themselves. As the DA said, there was prior incidences with knives. And I agree that this has been a long time with these same issues and that his family knows about it. In fact, his family contacted law enforcement 3 days before this happened. Because Mr. Sonnenberg was kind of out of control, acting crazy. He armed himself with a knife. Mr. Sonnenberg told the police, I want to go to jail. I want to go where it's safe. I think that the alternate PSI kind of talks about that a little bit more, and that's some of the charges that he's facing over in Polk County still. But not that it underscores the importance or the seriousness of his actions on the 16th. I mean, his family did try to intervene. They did contact law enforcement. They took him to jail for the night. I know we can't change the criminal justice system into a mental health system overnight. But this is what happens when we don't have the tools in our society to handle situations like this. At this time, he was not on bond. He was not on supervision. So there was nothing over him that could have, I guess, held him in jail right away. So to prevent the incident on the 16th from happening. Something that struck me that Deputy O'Toole said, he said, Andrew, you will never change. You never take responsibility. He is here. He took responsibility. He did not ask to go to trial. I believe he did with his previous attorney. He wanted to go to trial, but I know that before I became his attorney, he never looked at the discovery because he didn't want to. And when I told him that I would have to withdraw from representing him because I can't ethically go to trial if I know my client hasn't seen the evidence that the state has against him, he reluctantly watched the video. And from that second, his mood and his attitude about this case, 180-degree change. Many of our conversations end like this, or we have to stop because he really is remorseful. He really couldn't believe that Officer Sajak was there to help him. I don't think that he has a very good impression of law enforcement, unfortunately, and given his background and family involvement with law enforcement, I can see how that would be the product of that. But I literally physically saw the change in Mr. Sonnenberg, and I have every single time since I've met with him after he watched that video. And I think in the PSIs, he even tells the PSI that, well, my attorney showed me the video. I didn't know the officers were there to help me. He pled guilty to a very serious charge, and he is here and he is going to accept whatever the court deems is appropriate for him. Would the court be justified in giving him a max sentence? Sure. But Mr. Sonnenberg is not somebody who has had the tools that most people have growing up or even in their adult life. I'm not saying that he deserves a break, but I think that we need to recognize that and consider that. I disagree with him being evaluated previously in the federal and state systems. I've never seen a copy of evaluation. My client says that he was not evaluated before. So I think that a proper full psychological evaluation is absolutely necessary here. I don't know how far the court's authority can go with ordering a TBI evaluation. Mr. Sonnenberg's, after we discuss the PSIs, he realizes how important that would be to have evaluated, and he is going to work with the tribe once he is released to get that evaluation if he cannot get it sooner or in prison. Like I said, the defense is expecting a prison sentence, and we're asking for 6 years, 3 years initial confinement followed by 3 years extended supervision. Thank you.
Thank you. Sonnenberg, I'm now going to turn to you. If you wish to provide a statement here today, you may do so. You are not required to, but this is your only opportunity to tell the court anything about this matter, this case, you, etc., that you wish to let me know before sentencing. It's also your opportunity to correct anything that you may have heard that was stated incorrectly, or anything in these two documents in front of me.
First off, I'd like to say sorry to the law enforcement officers for because I don't remember that night. And the video shows my kid's mom came up first and said my daughter's still in there. But before that, the cops were yelling my name to help me. And I got trauma, you know, and during my incarceration in the feds, I just indulged in drugs. There's more drugs in prison than in some towns. But this changed me, man. And then another incident happened when my daughter was at school. She acted up and said what I said that night to the cops. I don't remember, but that's what made me change hearing that before I seen the video. And I'm sorry for the law enforcement officers to go through what they went through. And I know I need a psych eval, almost for myself, for my family, my daughter. And I'm not that type of dude. I just drugs and alcohol were in my system. And I lost my brother and my cousins. I still haven't grieved for my mom yet. I lost her in the hole. And that's why I pleaded guilty, because the video shows the cops were trying to help me, and I didn't know. I black out, and sometimes I can't. Well, I got short-term memory loss, you know. But I know that it wasn't right. I'm sorry for causing what they got to go through in life when they're kids, as well as me and my family and my kids. And sorry for the court to going through this, because I know it's their job to label me as a bad man. I'm not that type of dude. I was out there singing with my dad, helping the kids. I never got even a psych eval in the feds, period. I didn't get no help. In the feds, you pay money, then you get certificates from the dudes that are running it. So where's the help, you know? Just pay through your things to get certificates. It's rugged in there, man. In USP Florence, United States Penitentiary Florence, I never been to prison in my life. And they sent me there. Right when I get there, they give me, it's called the bone crusher. I didn't know that. They said, you gotta live with this daily. And I was like, what? And I just sat back and watched and observed. And going through that, throughout my bed, and not getting help with my head, because I was in a coma for a long time. The feds never looked into it. I never got his psych eval or none of that. They just threw me in there with the wolves. But I'm sorry for this night, man, and to the law enforcement officers. I'm not that type of dude, man. I'm a singer. I'm a dad. With that, man, I'm gonna seek help for myself, because the only one can do it is myself. And that's for me, my family, and my kids, man. So hopefully, come on, you guys come to a power and make you and your family dance. And that's what I do, man. Thank you.
Right, thank you. I have read all of the documents that I have been provided, the pre-sentence investigation report, as well as the alternate PSI. I have also heard now the statements of the two officers that were present that day, that night, as well as the statement from Mr. Sonnenberg. And I've heard arguments from the court or from the defense as well as the state. The court watched two body cam videos, the footage of what happened that night from the two officers' different perspectives. They are completely different videos. They're the same thing, same time, happened at the exact same moment the videos were recording, but they were from two separate angles. Now, had I watched only Officer Zajak's video, it doesn't look as serious. You hear Officer Zajak in a very calm voice trying to bring you down, Mr. Sonnenberg, trying to de-escalate the situation. And from Officer Zajak's body cam, you see you coming down with a knife and then beating on the door. And then all of a sudden, you see Officer O'Toole raise his weapon and shoot. From that body cam, if that was all the court had to view, it doesn't come across as serious until you watch the different perspective from Officer O'Toole. Then you get a complete picture of what happened that night. You see Officer O'Toole approaching the house, hearing from dispatch, he's got a knife, walking up, seeing Officer Zajac at the door, only trying to talk you down and de-escalate. We have a clear view, a clear picture of you with the knife. You're beating the door with your body. You take the knife in your hand and you stab the door multiple times. And in the video, you see just how weak and flimsy that door is. It's a cheap door. And you see the beating of the knife on the glass door and that the door keeps trying to give way. And you not de-escalating. You in fact escalate even more and you push through the door. Officer Zajac then has to run back because you are coming outside of the door with the knife in hand. Then Officer O'Toole reacts and responds in this split second. He has to think and evaluate the situation. And he shoots. Not to kill, to disarm. And you see that you were shot in the arm. You could have been shot dead. I'm not an officer. I don't know what they're trained to do. I'm going to tell you what I'm trained to do with my weapon if I'm in that situation is shoot to kill. You could have died that day. Officer Zajac and Officer O'Toole could have died or been seriously injured that day. Without Officer O'Toole's body cam footage, you don't get a complete picture of what happened. And it's very traumatic. It's very violent. And then we go back in time in that situation of what occurred on December 16th, 2025, and why the officers were present in the first place. Because there was a domestic in progress. A domestic in progress. When those words come over, I'm sure an officer's radio, and they hear that, just as I heard from the officer's statement, domestic in progress, heart starts pumping and escalating. Faster and faster, you get a rush of heat through your body. Anxiety raises. Fear exists. Yet the officer needs to perform his duty and his job and to protect. The officer does not get to have those feelings at that moment. But it doesn't mean they don't exist. Officer Toole at least got the moment right before to walk in to call his wife. That could have been the last time he called his wife. Domestic in progress. We have MM, your former significant other, who has a domestic abuse injunction, restraining order against you. We have your 6-year-old daughter and RL, the mother of MM. There could have been far more deaths that occurred that night. Domestic in progress. There has been a significant increase in officer-related shootings and or officer deaths responding to domestics in progress. And it's uncalled for. I have 2 officers who provided statements. And then I heard in one of them that the officer is human. They have feelings. That's true. Sometimes people forget that because they wear the uniform, they wear the badge, they have the gun, they have the taser. Sometimes the public sees them as robots. People who should just respond and act without thought. And to take all of the criticism, to take the spit, to take the urine, to take the punching, to take the hitting, to take the knives and the guns. Officers are human. They have a job to do and they did it that night. They protected, they served that night. But for the fact that they are there, we have a woman and a child that are safe. But officers, I saw an officer cry. You don't see that very often. Officers experience trauma just like everybody else. They feel pain emotionally and physically. They are victims too. And when I heard your statement, and I heard the argument from your attorney about your perspective of what happened that night, I understand and I hear from your perspective what happened that night. That you were shot in the hand, you were shot through other places, that it was very traumatic for you, that it totally changed your perspective, that you're trying to heal from that night. There's nobody to blame for what happened that night. There's nobody to blame for your injuries but you. Every single step that was taken that day, every single action, by inhaling the substances, by drinking the intoxicants, by going over to a place you knew you legally were not permitted to be, to be near people you were not permitted to be around was calculated by you. Every single thing that happened that night, including getting shot in the arm, was caused by you. I've had the pleasure of sentencing Mr. Sonnenberg a handful of times. The first time Mr. Sonnenberg was in front of me, I remember distinctly and clearly. He was just released from either an extended supervision stay or a prison sentence. He was just out, got into some trouble, but then he found out and discovered he was expecting a child. I remember that clearly. And I remember how excited you were, Mr. Sonnenberg, how happy you were that you were going to be a dad. Because that's all you ever wanted, is what you told the court. Be a dad. Take care of your daughter. Raise her and show her how to be a good member of the community, to teach her your tribal culture and your experiences and those things. I remember clearly. That time, he told me, this time, prison has changed me. This time, I have a daughter and I have a purpose. I'm a different man. Those were words that came out of your mouth, I recall. And yet, you did something awful that night. And I'm not saying I'm not saying towards the officers. You put your 6-year-old daughter in harm's way. Your 6-year-old daughter, who, for the love of God, I don't know if she's here supporting you or not supporting you. She was here today. She would be in here today hearing all of these things about you, seeing a video that literally took me aback. Cold and calculated. It doesn't matter that you are under the influence of alcohol or drugs. That's an excuse. And in your statement, I continue to hear excuse after excuse after excuse. Prison made me this way. Going to prison, they don't change, they don't help, they don't direct. And in your statement to PSI author, when asked if the justice system works, you said, fuck no. You believe the only thing that they can do, the system, is help you before you get out. But they don't even help you in there. You believe the initial charges are excessive. You want to withdraw your guilty plea based upon dissatisfaction with legal counsel and how your case is handled. I don't know if that's prior to Ms. Landgraf or during Ms. Landgraf. It's got to be during Ms. Landgraf because I accepted your plea. She handled your plea. So these were statements you made. You made after your plea. After this time, you had the poof epiphany that you did wrong and that the officers were there to help you. I didn't see an epiphany. I didn't see accountability. I see someone who's trying to dodge responsibility. Someone who's trying to pass the buck. I understand you had a very traumatic life. I read, very traumatic life. I've heard from you in various other times, the trauma that you've experienced. What can society expect from the upbringing he had? Well, we don't expect someone to be a violent offender. We don't expect somebody to not take advantage of the services and the programs that the community has to offer. We don't expect somebody to pass the buck and say that it's the system who needed to test for a TBI or a psych eval or do those things. We expect that the system is there to punish and it's there to rehabilitate. You can only rehabilitate if you choose to do that. Change your habits, change your associates, change yourself. That's the only way. And prison isn't easy. It's not supposed to be easy. It's not supposed to be easy. It's supposed to be a punishment. We all agree that this is not a prison, or this is not a probation case. This is a prison case. That's right there on the table. I have an alternate PSI recommending 3 to 4 years of initial confinement, 4 to 5 years of extended supervision. I have a DOC recommendation of 5 to 7.5 in with 3 to 4 out. I have defense recommendation of 3 in and 3 out. All three very different views and takes on the case. But if they all agree, it's prison. Because correctional treatment has not yet helped you, but the community, you have not availed yourself of the services in the community to rehabilitate. And this was an extremely, extremely serious offense. I have to take all of the victims into account, all of them, not just the law enforcement, MM, your daughter, RL, all of them. I have to take the community into account as well. Will the community be safe with you in it? At this juncture, it's no. After watching the video and knowing the facts of the case, your attorney is correct. You were not charged with anything. I mean, it's serious, a Class F felony and some misdemeanors thrown in. But it's surprising that you weren't charged with something more serious from watching the videos and knowing the potential harm that everybody was in that night. But you did plead guilty. You pled guilty to a serious Class F felony. You're here knowing that you're going to be sent to prison. That's one thing. Everybody can agree that December 16th is a terrible, rotten, awful day. And nothing can change that. No magic wand, can't take away the impact on the victims. It can't take away the trauma that your daughter has experienced. She needs therapy. She needs therapy. I do have to look also at deterrence, specific deterrence, as Mr. Schmidt argued in his statement that enough's enough, this was violent, this was serious. Mr. Sonnenberg needs to be deterred from doing this type of conduct again. But not only that, general deterrence. Enough's enough. When are we going to respect law enforcement? Are they always right? No. Am I always right? No. We have lost respect in our justice system. Yep, there are things that are broken. I see it every day. There are things that this county is trying to do to improve that and to make it better. One thing is we need more respect. We need to follow the rules. We need to follow the law. So the gravity is very serious. I wish I could say that you had rehabilitative prospects that you could receive and do on your own behalf and without needing the assistance of prison. But I can't see that, at least at this point. I know one driving force is your daughter. Be better for your daughter. Be better for your daughter. Because I have seen your softness. I have seen that you are a caring individual when you're not drinking, when you're not using substances, when you're not acting without thinking. What the court needs to focus on the most here in this case is the seriousness of the offense, as well as the needing to protect the public. And this involved an officer shooting, officer-related shooting. You got shot. But it was an incident that escalated to the necessity to do that. So it's very serious, again, with the other victims. So with that, and needing to protect the public and to ensure that the public understands the severity of these types of incidents, the court is going to sentence you to 7.5 years of initial confinement, 5 years of extended supervision. It is the max sentence because I believe that this escalated to the max. That video was critical for the court's perspective. Black and white, reading on paper what occurred and hearing arguments that are, let's face it, each one-sided, the state sided, the defense sided. It doesn't give me as much as watching that video. So it's a max sentence. Anything less would unduly depreciate the seriousness of this offense. You are not eligible for challenge incarceration program, and due to the severity and violence of this offense, you are not eligible for the earned release program.
Does the court mean substance abuse program too?
That's all of it. No early release programming, no substance abuse, no early release. This is violent. Conditions on extended supervision, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Regular alcohol and drug testing. Regular means at least 2 to 3 times a week. A TBI evaluation, a psych evaluation. Follow all recommendations. We're asking for no contact with MM. Ms. Bauer? No contact with MM. You can have contact with your daughter through letters. You can contact your daughter through letters. Your daughter can talk to you on the phone, on video calls, all of those things. Mr. Sonnenberg.
Yeah, can I speak?
What?
Can I speak?
Yes.
Yeah, me and my baby mama want to get married, and that's what's good.
That causes significant, serious concern with the incident that occurred here with having the restraining order, all of those things. At least at this moment, it's a no contact. She has to go through programming in order for the court to do no abusive contact. I'm not going to hear her on that point right now. I guess I will hear her on that point. However, the court still has its reasoning for any case like this, any domestic. Both parties must go through programming. And now you reminded me, domestic abuse programming. Completion of a domestic abuse program. $518 in fines and fees. Court will enter a civil judgment against you. If you don't pay it, the court will issue a warrant, 6 months in jail you could sit. This is a felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. How many days of jail credit? Not including today.
246.
246 days of jail credit. Ms. Bauer, the court will amend or allow the Department of Corrections, I will amend upon proof that she has completed the domestic abuse program. It's no contact until I get proof of the program. But you may still, again, have contact with your daughter through letters, through calls, through those things.
Can I get visits from them in prison? Because my baby's going through, and me being away from her is gonna give her more trauma. That's my life right there.
Quite honestly, I don't think that my conditions on extended supervision are applicable while you are in custody. So you can double check with your DOC agent.
What does that mean?
Means when you're in prison, I don't think my extended supervision conditions of no contact are applicable. I don't think they apply until you are released. However, I'm still not going to change it to no abusive until I have confirmation of a program.
I'm not gonna abuse nobody from here on out. I just want visits from my daughter because that's gonna help me. She needs,
It will help you.
she needs me in her life.
I 100% agree, Mr. Sonnenberg. She needs you healthy. She needs you sober.
Yeah.
She needs you to be present in her life to the best of your ability.
So I can,
She needs you to make changes.
yeah, I'm gonna. So she can come see me in prison, like when I get there?
Yes.
Thank you. Both of them?
MM would need to get confirmation from the prison or from DOC that these don't apply in the prison setting. It's my belief they don't, but I'm not confident on that 100% because DOC is the one who enforces them.
It's gonna be a hard time not seeing my babies.
However, again, Ms. Bauer's going to talk to her about the program. She can get that done within a couple weeks,
Okay,
and
Your
it
Honor.
can be no abusive.
Thank you.
I just need to ensure, especially due to the violent nature of this incident involving her and your child and a knife and a very irate Mr. Sonnenberg, I need to ensure that they are protected and they are safe too.
They will be. You won't hear nothing from me except how good I'm gonna be.
That's what I want to hear. And I want you to be good. I want you to do those things to improve yourself. We've talked about this before.
Yeah, but being shot and being here, I got shot right here. A little bit to the more, I wouldn't be here, but I'm here for my daughter. You know what I'm saying? I'm sorry for the law enforcement, what they gotta go through. I'm sorry.
Would have, could have, should have. Sorries don't fix anything or change anything.
Yeah, no,
Action does.
yeah.
Change yourself.
I'm gonna.
Change yourself, and then law enforcement will be happy. The court will be happy. I believe that covers all the conditions. I need your DNA. You're going to provide that. I gave jail credit. I gave the amount owed. Said the felony. What am I missing, Mr. Schmidt?
Nothing from me.
What am I missing, Ms. Landgraf?
Judge, I don't believe you're missing anything, but I would respectfully ask that you reconsider finding him eligible for substance abuse program. I understand that inmates are eligible when there are 4 years or less remaining on their sentence, but given the court's ruling on that, I think the court could order that he could be eligible if he only has 2 years of incarceration left, so he has some kind of program before he gets out.
Reconsidered, denied. A sentencing court can determine that a defendant is ineligible for these early release programs if the inmate, even if the inmate otherwise meets all of the necessary requirements and would be eligible per DOC. However, I'm again denying his ability to participate in early release due to his record, due to the violent nature of this crime that is before the court today. Denied.
Nothing further.
One last thing, Mr. Sonnenberg.
Yeah, I'd like to appeal this because
Good, appeal, 20 days. Talk to your attorney. We're done. Escort him, please.